Ladies and gentlemen, welcome to the QUT Faculty of Law, to our symposium on copyright law and the creative industries. The purpose of this event is to bring together creative practitioners, cultural, institutional representatives and legal academics and lawyers to discuss the intersection between copyright law, creativity and culture. As is always the case at QUT, in keeping with the spirit of reconciliation, we acknowledge the traditional owners of the lands where QUT now stands and recognise that these have always been places of teaching and learning. We wish to pay respect to their elders, past, present and emerging, and acknowledge the important role Aboriginal and Torres Strait Islander people continue to play within the QUT community. Bruce Baer Arnold is an expert in intellectual property and privacy law and innovation policy from the University of Canberra. He's done lots of interesting work cutting across an array of different technologies. Today he's going to be talking about riddles wrapped in enigmas within mysteries, artificial intelligence, secrets, online games and copyright.
Okay, thank you. So Roger Ebert, writing about the dominant cultural form of last century, described movies as empathy engines, copyright-protected works that allow us to momentarily share the fears, hopes, kindnesses, cruelties, uncertainties, and desires of strangers. The dominant cultural form in coming decades is likely to be immersive, networked, multiplayer games, private virtual worlds in which global audiences interact with each other and interact increasingly with increasingly sophisticated algorithms. Those worlds, like contemporary movies, will be a matter of industrial scale and corresponding investment rather than artisanal production. Their creation will not persuasively be attributable to the likes of Irving Thalberg, Baz Luhrmann, Steven Spielberg, Orson Welles, or Martin Scorsese. They will instead be a manifestation of experience engines. In other words, a combination of big data and artificial intelligence to dynamically generate an online space that becomes more compelling as algorithms assimilate data from both inside and outside that game. Those spaces will be commercially viable if they provide the consumer with a rewarding experience, an experience as a participant in the specific proprietarian world. And we can construe participant experience in terms of colour, action, sound, imagery, dialogue, novelty, and excitement. The hedonics, in other words, that we call entertainment, and that we've often sought to incentivise through copyright. There is, however, another dimension to conceptualising virtual worlds as experience engines, a dimension that raises questions about copyright, trade secrets, contract, and data protection. And that dimension is a form of what recent scholars have characterised as surveillance capitalism. My forecast about the future of virtual worlds, and its speculation, my forecast is that they will be founded on artificial intelligence that draws on user interactions with those worlds, in other words, is dependent on exploiting data about what people bring to the game, about how they play the game, and verification of inferences about what they want from the game, so that we have ultimately a quite dynamic system. Now, much of the literature on artificial intelligence has the subtlety of medieval theology, along with the ferocious infighting about taxonomies. I suggest that today we don't have time for that, and I suggest that we don't need to. For the moment, let's simply think of simply think of AI as algorithms for collecting, interpreting, and responding to data. Such responses in experience engines will include the generation of dialogue that reflects what a user brings to a virtual world. For example, an indication of gender, experience, and prior consumption patterns, and how the user responds to opportunities within the game, within the world. Responses will also include the provision of new opportunities and new scripts, new themes, if you like, new stories, generated iteratively through billions of interactions with hundreds of millions of people, many of whom will visit each world each day. Now, the boundaries of that generativity, what we might otherwise call creativity, will be set by what each virtual world's owner perceives as market demand, relying on user metrics that are more authoritative than what we see in the film and television industry. Analytics matter, and not just to precarious academics whose teaching is tracked on learning platforms. People with an interest in the studio system may recall the famous comment by Harry Cohen, the chief executive of Columbia Pictures, many years ago. Cohen said that he had an infallible sense of whether a movie would be successful or not. And on what basis? Simply that parts of his anatomy tingled in the Columbia Pictures screening room when he watched a future hit. And Herman Mankiewicz, in many ways the brains, the spirit behind Citizen Kane, Mankiewicz responded, "Imagine the whole world wired to Harry Cohen's ass." Experience engines as a manifestation of surveillance capitalism would, in principle, reduce such subjectivity by wiring decision-making to the seats of 100 million users, some of whom, we hope, might actively foster innovation and diversity. So my contention is there will be a ghost in the machine, but unlike Citizen Kane and The Big Sleep, it alas won't be a genius such as Mankiewicz and Faulkner. The ghost will instead be proprietary software that engages with population-scale databases of past interactions to shape current and future interactions. The ghost will be convenient for investors because the ghost won't go on strike. It won't demand royalties, it won't get drunk, definitely won't run for president, and it won't reside in a jurisdiction with high income taxes. It might not produce great art, but then when we're thinking about copyright, we remember that greatness, or indeed true novelty, isn't a prerequisite for copyright protection in Australia and overseas. So, where might we be heading with intellectual property and other law in relation to what I'm suggesting will be future worlds? Churchill famously stated, "I cannot forecast you the action of Russia. It's a riddle wrapped in a mystery inside an enigma. But," said Mr. Churchill, "perhaps there's a key. That key is a Russian national interest." My contention in this presentation is that copyright offers a somewhat rusty key for the protection of the coming virtual worlds, and just as importantly, for access, ongoing access to those worlds. And I'll return to access shortly. But as with Russia, a better key to understanding incentive, copyright if you like, access and protection, is instead commercial self-interest, uncomplicated by any dignitarian respect for cultural production by gifted or simply diligent individuals. Now, I suspect somewhat at odds with previous speakers today, I don't think questions of equity in accessing, creatively reworking, and preserving a major cultural resource will be solved by adding yet another wing to the haunted house that we know as the Copyright Act 1968. Or, more practically, by providing better funding to underpin legal deposit. I don't think that copyright is dead. I do think, however, that it's ill-equipped to address some questions that will be significant in regulating virtual worlds as both a type of digital platform, and we might recall the latest competition policy announcements in Europe and the US, and as experience engines. Now, I gave my promise to Matthew that I wouldn't run over today, so I want to wrap up quickly by exploring some of the questions that I see. The essential value in experience engines is their store of data about how people behave, how they behaved in the past, how they are likely to behave in future, rather than the sounds, dialogues, images that feature in those games. We don't copyright data as such, and much of what's used by the engines, and will, I suggest, be used by the engines will lack sufficient originality. So we might want to think about, do we need some sort of discrete database right? Something that covers the interaction data that's extracted by the operators of those worlds through the algorithms. Is it sufficient to wrap up the data as a matter of trade secrets? I'll also suggest that the value inherent in the engines is what we might characterize as their smarts. In other words, proprietary software, emphasis on proprietary software, in the form of specific algorithms for mapping user interactions, analyzing those interactions, and thence providing users with new opportunities. The expectation within parts of industry is that the real challenge is to teach the engines to engage in what we'd otherwise dub learning, giving them a real smarts, if you like, some sort of intelligence, rather than sort of mechanistic sorting and mapping. So a smarts that might, in terms of intellectual property law, be best protected under patent law rather than as literary expression, so not as copyright. There are some other implications. We haven't conceptualized platform operators as data custodians rather than data owners. It's difficult envisaging application of the EU General Data Protection Right to interaction data that isn't tied to a discrete individual, although privacy and potentially confidentiality law should encourage a custodianship ethic regarding user financial details and other identifiable attributes such as gender, express or implied sexual orientation and age. Now, I jibed earlier about the ghost in the machine. As Cummins and Bond articulated almost 100 years ago, we don't grant copyright protection to inhabitants of the spirit world, unlike the mediums or possibly the scribes. Recently, we haven't granted copyright to selfie-making monkeys and artistic elephants, though as one of my godchildren commented the other day, the monkey is so much more handsome than me and definitely takes a better photo. Now, as things stand, copyright in a virtual world could be construed as, in terms of a cinematographic work. Who would have the copyright there? The owner of the world, not the software. And irrespective of whether AI is sufficiently sentient in future to justify recognition on a dignitarian basis as a legal person, my sense is that we would reject recognition on public policy grounds. That would save us from the conundrum of an entity having copyright in itself. And finally, let's not forget that we're considering private worlds. These are not public worlds. And those virtual spaces may be sufficiently satisfying to attract recurrent visits by millions, or indeed hundreds of millions of people, but ultimately, like Facebook or old-fashioned Luna Park, they are private property. As such, entrance to and enjoyment of the virtual world will be subject to conditions established by the experience engine's owner under contract law. So there'll be no personality or performers' rights for individual players, no ownership of your feats, if you like, or if you're one of those people who's playing in Animal Crossing, no ownership of that island that you've so lovingly and innovatively curated, no Marrakesh, if we're concerned about equity, no private backup copies, no mandatory deposit in a public archive. You can have weddings and funerals aplenty, but you won't be able to have rallies by data subjects, in other words, by users, protesting your algorithmic overlords. And finally, a big thanks to Drew Goff, Tess Watson, Jane Diedrichs, and Katie Lay for encouraging me with this speculation and also encouraged me to write a book about Animal Crossing, which we hope will come out at the end of next year. Thank you.